Good afternoon, everyone. Welcome to the latest of Phil Fisher's Privacy Webinar Series. My name is Renzo Marchini, and I am a partner in the privacy practice in London. Thank you so much for joining us. Today's webinar is called All Change on International Transfers with New Standard Contractual Clauses. I will, of course, look at the new EU SCCs that were finally issued last week. They can be used from a couple of weeks' time, not quite yet, as we'll see, and then must be used for all new deals within a few months. They've been a long time coming. Data flows have got much more complex since the current SCCs were adopted back in the early noughties, 2001, 2004, for the two versions of the C2C SCCs and 2010 for the current version of the C2P SCCs. Since then, we've had a wholesale review of data protection law in the EU with GDPR. Privacy professionals have known for a while that the old clauses were in any case, leaving aside GDPR, not fit for purpose, not covering specific common transfer scenarios, not reflecting Article 28 of GDPR, and not allowing use by non-EU based exporters. We've also had SHRMs too, and this is the key factor in how the clauses look, as we will see. We've had Brexit, and this is now a first substantive point of divergence between the EU and the UK on privacy matters, and there will be more. I'm delighted to be joined by two colleagues who work a lot with me on international data transfer issues. Kirsten Whitfield, a director in our team, and Charlie Guile, a solicitor. I'm especially grateful to Kirsten for being a late substitute. I'll set us all up with an introduction to the structure of the new document. Charlie will talk to us about some of the challenges and the improvements in the new documents. And then Kirsten will take us through SHRMs issues and how actually to use them in practice. We'll end up with some Q&A. We will finish within the hour, that is at 5 p.m. Before we come on to substance, I have a few points about us and also a few housekeeping points about the webinar. For those of you that do not already know us, Phil Fisher is an international law firm with offices across Europe, in Silicon Valley and in China. Our privacy team works across all of those offices. We are a collaborative team providing strategic and actionable privacy solutions. Turning to housekeeping, please do ask us questions using the question function on your screen. We might be able to try and take them as we go along at convenient points. And so do keep them coming. As I say, there will be Q&A at the end as well. And if we do run out of time, we will respond to questions posed in writing. Next week, we'll send you a copy of our slides and indeed even a recording, which in fact is going to be also posted on our YouTube privacy channel. So do not feel as if you have to scribble everything down as we go along. A couple of other points. Do please subscribe to our blog, which has a regular set of posts on topical issues. And I'm sure a lot of you do and might have seen Phil Lee's blog on the SCCs earlier this week. And also subscribe, of course, to our YouTube channel. And do keep an eye on more of our webinars over the coming months and weeks. So turning now to the main meat, a quick update of how we got there. I mean, I could have started this chart, this slide back in the early noughties with the directive coming into force in the old SCCs, but let's start in May 2018, wholesale review of data protection law, and importantly, Article 28, and also additional subject rights, all of which were not reflected in the existing SCCs. So immediately we had a gap between the legal tools for international transfer and the legal regime. The gaps got worse. In July 2020, of course, we had the SHRMs 2 decision. God, is it really almost a year? It is. And after that SHRMs 2 decision, there was much a flurry amongst the privacy world in trying to make sense of it and trying to do the best that they can, given the jurisprudence of the court. In December, we had the Commission publishing draft SCCs, which are now finalised for consultation, and those of you that have studied it closely will see some differences, but generally they broadly reflect what was out for consultation. At the same time, the European Data Protection Board published draft recommendations, guidance on how to handle SHRMs 2. And of course, there's a tension, I think, has been well explored now between the European Commission stance on these things and the European Data Protection Board stance on how to handle SHRMs. We now have the final SCCs in June 2021. Is the Commission winning? I don't know. I was dreading that today the European Data Protection Board would publish their final recommendations. Actually, to be honest, I haven't checked. I haven't heard that they have come out, which is a blessing for us today. But the final guidance from the EDPB will be due sometime in the coming weeks. So we've got the new SCCs and therefore the EU, and we'll come back to this. The UK has already said, the Information Commission has said that they will be publishing their own version of UK SCCs for consultation sometime this summer. Now, a word of warning, one slide on this topic only. There was a second set of standard contractual clauses published last Friday. Those are not the subject of today's webinar. Those clauses are a standard form of document to reflect Article 28 for use with a controller and a processor within the EU with no international transfer, still called standard contractual clauses, but a very different instrument from the one that's the subject matter of today, and the one that frankly most people understand as standard contractual clauses. They normally use that expression in the context of international transfer. A couple of words on those. They're supposed to be, try to avoid having to negotiate DPAs, but I don't think it's going to keep many people too happy. I suspect there'll be very little take up of them because most vendors won't like some of the provisions that are in there, and they'll start amending and tinkering. And once you start amending and tinkering, what's the point of a standard form document? It's not mandated that you've used them. It's just there to be helpful to the community if they wanted to. So moving on, let's not confuse by talking more about those SCCs. So the new European International Transfer SCCs, how do they work? So the old ones, let's talk about the regime now. The old ones cover two types of transfer, controller to controller and controller to processor. For controller to controller, there were two sets, one adopted in 2001, one 2004. Most people tend to use set 2. Is all going to be moot very soon, but two sets of clauses for two particular transfers. And there's a gap there because it doesn't deal with some of the common data flows which exist. That's now fixed. Some of the gaps are now fixed anyway with the new SCCs. There's now one set of clauses, but they're modular. And modular in the sense of as you go through the different provisions, it will say, if you're in module A and C, use these. If you're in modules B and D, use those, and so on. So good signposting as to which provisions apply to which type of transfers. So the type of transfers that are covered, the first two, module 1 and module 2, are exactly the same as the current regime, but with some improvements that Charlie will talk about. Modules 3 and modules 4 are transfers which are not currently covered. And just for those of you that haven't actually come across these scenarios, we have a slide or two just to describe those two because they're not so common. So module 3 covers a processor in the EU transferring data to a processor, or perhaps more accurately, a sub-processor outside the EU. So if you imagine a situation of an EU cloud provider with EU customers, it is a processor of that customer's controlled data, but the service is actually hosted on Microsoft or AWS or somewhere in the US on some non-EU infrastructure somewhere. At the moment, on the existing SCCs, that transfer cannot actually be legitimized, at least not clearly so. There's various risk-based approaches you can do to fudge the solution, to fudge the current weapons for that particular transfer, but nothing clean-cut. Now that gap's been fixed. Module 3 deals with this scenario. Module 4 deals with a scenario which looks like this. This time, the EU service provider as a processor has got a non-EU customer, and the data is transferring from the processor back to its origin, back to the controller. Now, people might be surprised they haven't seen this as to why that's captured at all by the restriction in Chapter 5 of GDPR? Well, it's captured because GDPR applies generally to controllers and processors, and Chapter 5, the restriction on transfer, also prohibits processors sending data out of the EU without putting in place some sort of mechanism, appropriate safeguards with SCCs in this particular case. So Module 4 deals with it, and that's sometimes called a reverse transfer. And again, Charlie will talk a little bit more about that in the coming slides. Now I want to sort of delve into actually the structure substantively of the clauses. As I say, it's all fairly modular. It's split into 4 sections, and within each of those sections there are signposts as to which ones of those, which language need to be adopted for particular modules. Section 1 sets the scene, if you like. It's got some definitions, parties, and precedence type of language, and it's got something called a docking clause, where parties can sign up to an existing SCC arrangement even though they weren't the original signatories. Section 2 deals with obligations of the parties. It contains the real meat, data protection safeguards, purpose limitation, all those sorts of good stuff that we all know, how to handle data subject rights, how to handle onward flows and use of sub-processors. Section 3 is the SHRMs issue. Kirsten will be coming back to this and talking about it in a little bit of detail, but it tells you how to deal with foreign law enforcement requests for data. And lastly, Section 4 deals with boilerplate, if you like, termination, governing law, and jurisdiction type of provisions, again with variation depending on which ones of the modules you are actually addressing at a particular time. Apart from the substantive clauses, there were 3 annexes. Annex 1, dealing with the details of the transfer. Annex 2, security measures, and Annex 3, list of sub-processes. Annex 1, details of a transfer, are more or less similar to what you've currently got in the SCCs. Who are the parties, what's the purpose of a transfer, what data is being transferred. But there's much more in there about the description of the data when you've got a sub-processor involved, and particularly in the C2P and P2P scenario. Annex 1 says that you've got to set out the details of what processing a sub-processor might actually be involved in. That always has to be completed. Annex 3 also deals with sub-processing type of arrangements, but there, as the text at the bottom of the screen underneath the table says, the bottom right bullet point, Annex 3 has to be completed with a list of all the sub-processors if you're going for specific authorization rather than general authorization. And this sort of echoes the language that's currently in Article 28, where, as people will know, the processor must get permission, authorization from its controller, customer, in order to subcontract. And it can be specific, i.e. you name people, or general with an updated list with a right to object. And that's reflected in the SCCs. And if you're going for specific, Annex 3 needs to list those types of, list the specific sub-processors that are being used. The other point to make on the annexes is in relation to security measures. So security schedule does appear in the C2P existing clauses, not in the C2C one, but now you need to put in place security measure annex even with C2C transfers. So that will be a change for a number of people, a number of organizations. And the security measures, we have a big instruction as a drafting note in the Annex 2 to say they cannot be generic, they must be specific. So no longer can you get away with putting in place appropriate technical and organizational measures. You need to set out what those measures are at some level of granularity at least, and examples are in fact given of the measures and controls that could usefully be described. And now I'll hand over to Charlie to delve into a little bit more the improvements and challenges of the clauses. Take it away, Charlie.
Thanks, Renzo. So Yeah, now realistically, we could spend probably the whole hour, if not a day or longer, delving into the different provisions and where these are arguably approving the SCCs or where sort of difficulties or challenges may arise for organisations. And equally, these will vary and be of more of concern to some organisations than others. So we pulled together sort of some key high-level points. So kicking off with the good news first, as always, some of the standout improvements from the SCCs have been touched on by Renzo already, including that sort of modular approach that the SCCs adopt, which provides for clauses for each type of transfers and plugging that gap from the old SCCs or the docking clause that he mentioned. So adding to this is that the data exporter can now be based outside of the EEA. So the new SCCs provide a solution for those non-EEA based controllers and processors who transfer EEA personal data. They do not require that data exporter to be established in the EEA, and so they can now be signing the SCCs as a data exporter. As I'm sure some of you already know, the old SCC didn't allow for this. So they required that the exporter, which was always a controller, was going to be based within the EEA, which actually, of course, didn't reflect what was happening in practice. And there were some different drafting approaches taken to try and deal with this issue in practice and get sort of something in place between the parties. But I'm sure this change will be welcomed by many organisations and making this point much easier to deal with. And moving on to the next point. So as Renzo explained, one of the modules within the new SCCs are those processor to controller transfers, what we might call a reverse transfer. And the approach taken in the new standard contractual clauses, where that EEA processor transfers back non-EEA personal data to the controller, which is outside the EEA, are much lighter touch than sort of the other modules in the SCCs. You'll notice when you have a look at the document that the modules on those are much lighter touch, which of course is what we would all hope for, but it's also great for those EEA processors that will be dealing with this. I'm sure they'll be grateful as it avoids these clauses causing any sort of constraints or friction when entering into arrangements, but also ensuring that they can compete with those non-EEA based processors for businesses who wouldn't then have been subject to similar constraints. And then moving on to the next one. Yeah, so this is looking at data importer audit certifications. So we're dealing with the good news first. So one of the positives to come out of the audit provisions is as an express reference allowing data exporters to take into account a data importer's relevant audit certifications when deciding whether to carry out a review or an audit. And this reference appears within the controller to processor and processor to processor provisions, so your modules 2 and 3. I'm sure this sort of practical addition will be welcomed by many processors. The audit provisions are often sometimes more difficult an area to agree on. But the audit section generally is not all gold stars, and I will pick up some challenges in a moment. And then finally, moving on to the last improvement from this section. So the SCCs recognise sort of there may be local law conflicts for data importers, and they've built this into some of the provisions. So under the GDPR, there's already recognition for this for some areas under Article 28, but this is limited really to member state or union law. Under Article 28, I think it's 3G. So the approach in the new SCC is slightly broader and just refers to sort of local laws, making this a bit more applicable to those non-EEA based importers. This sort of more practical approach means they're more workable for those non-EEA based data importers who would have potentially been at risk of deciding whether to breach the agreement and the SCCs with the exporter or being in breach of local laws. So to bring this one to life a little bit more, as an example, the provision on the return or deletion of data in the SCCs, they're drafted so that the importer is aware that the importer may be subject to a local law requirement. That restricts them then from actually complying with that sort of request for return of data or deletion of all data. And they may be required to retain the data for a longer period of time to remain in compliance with those local laws. And the SCCs allow for this and require that where an importer is required to retain this data to comply with local laws, it is still obliged to continue to ensure compliance with the standard contractual clauses. So this ensures that that personal data is then protected to the standards of the standard contractual clauses for this retention period. And moving on to some of the challenges. So aside from the general challenge of trying to navigate the document itself and the different modules and trying to get your head around what you need when and what works, there are several challenges, some of which Renzo has already touched on, for example, around detail required in the transfers annex, or as Kirsten will go on to cover, around sort of government access requests. But dealing with the first one, so it's looking at the potential for conflicts with any data protection agreements in place. So whilst at first glance, the SCCs look great in terms of having this sort of really, might have to go back one, Renzo, yeah, having sort of a really comprehensive nature for data protection terms, that might look really great and seem like a strong positive. There's obviously concerns there that this could inevitably conflict with existing data protection terms that are in place. I'm sure many organisations have spent at least the last 3 years finessing their standard data protection agreement position and negotiating these possibly quite extensively in some of their contracts. And there are going to be instances where the SCC terms conflict with these sort of commercially agreed terms. And as with the old SCCs, the SCCs make it clear under Section 1 Clause 4 that in the event of any conflict, the SCCs will prevail. So what does this mean? It may mean that it's not necessarily a simple case of being able to roll out these new SCCs and just have them sitting alongside your existing DPAs without that risk of items in the DPA being in conflict and them not being workable. So terms need to be carefully reviewed alongside the contractual terms to ensure that wider contract can work with the SCCs. To again bring this sort of point to life a little bit more, looking at the liability provisions. So this is actually an unresolved issue from the old SCCs, and it's not completely new or unique to our new standard contractual clauses. But parties will have no doubt negotiated quite extensively any commercial liability provisions. However, the SCCs will also have their own liability provisions. So those carefully worded or negotiated protections on liability and caps that you managed to agree may actually be seen to be watering down some of the protections offered in the SCCs. And it's not clear if those agreements around parties' liability in sort of wider commercial agreement would be allowed, as if it effectively placing caps on sort of liability under standard contractual clauses.
Charlie, before I move on, a question from the audience, which I'll quickly address, which is whether, like the old SCCs, can we modify the clause? I think you sort of touched on that, but maybe not as expressly as the questioner here is getting at. Can you amend them? And the answer is no, you can't amend them. At least you lose the protection that they afford you for dealing with the transfer restriction if you do amend them. But you can have additional clauses, as you know, as Charlie says, in a DPA, which mustn't be inconsistent with them. And then there's question marks as to what extent any particular language, such as liability language, would actually constitute sufficient inconsistency for the protection to fall away. And that issue hasn't fully gone. But yeah, the short answer to that question is no, they can't be amended. They've got to be adopted, and nothing inconsistent can be in any other accompanying contract. Back to you, Charlie.
Thanks, Renzo. So yeah, moving on to looking at something a bit more specific to one of the types of modules is looking at the controls controller module. And there is, in that module, there is an express obligation on that importing controller to notify the relevant supervisory authority of any personal data breach suffered. So what this means can mean in practice is that even those controllers that are based outside the EEA and that are not even subject to the GDPR under Article 3.1 or 2, but still receive EA data, would then be required to notify that relevant supervisory authority if they suffered a personal data breach. The challenge here is that actually those specific controllers falling under this non-EU based controllers may not actually have those processes or procedures in place to currently deal with this, so it's an additional hurdle there for them. And linked to this is the next challenge, which is looking sort of generally at those C2C modules in the SCCs. And they're pretty comprehensive, almost as much as the processor modules. And obviously, we'll be aware that when we're sharing data on a controller basis, they should have agreements in place. But under the GDPR, there isn't sort of the prescribed clauses like we have with a joint controller relationship or the controller to processor relationship. So actually how the SCCs are drafted, they are potentially quite onerous generally, and what perhaps separate and independent controllers would usually want to contractually agree to. There'll be those controllers who are already subject to the GDPR and so already subject to those requirements, but may not usually expect to contractually oblige to these requirements for somebody else. And then equally, there's those non-EEA based controllers who I just spoke about, who again will have some quite onerous obligations on them who weren't previously subject to similar GDPR requirements. And moving on to the next slide. So looking here at documents, and it's a fairly grey and dull image on the whole screen. It hasn't, there's no brighter picture of documents. But looking at this point, yes, accountability is a key part of the GDPR, and it has come through again in the SCCs. So there's various different provisions in the Standard Contractual Clauses that place obligations on parties to ensure effectively that there are documents to prove their compliance. And then depending on the scope of what that obligation is, then the importer may be also obliged to make these available to the supervisory authority on request. So this includes just your general sort of broad scope of documentation to demonstrate your compliance with the Standard Contractual Clauses, but also documenting legal assessments around government access or any sort of SHRMs assessment. But this is more of a practical challenge for parties to deal with, looking at how you build this additional accountability piece into existing data protection and potentially your contracting processes. So considering whether actually how you're going to document this information, and are you able to leverage your other compliance records or processes that you've already got in place for GDPR, and equally some sort of wider organizational awareness or training on these new requirements may be required, or potentially additional resource may be needed if this is actually going to be a larger scale effort for you to have everything documented in this way. And then moving on to the next item is looking at the P2P module of the SCCs. So how this is drafted and how some of the provisions are drafted under this module suggests a sort of a level of or a direct interaction between the sub-processor and the ultimate controller. So, for example, under the breach reporting requirements in Section 2, the importing processor, so our sub-processor for this purpose, is required to notify the data exporter of a personal data breach, but also, where appropriate and feasible, the controller of the controller when they suffered a personal data breach. And whilst this has that caveat of where appropriate and where feasible, it is a question as to whether this is likely to happen in practice, and equally whether that importing processor is likely to even know who the ultimate data controller is. Similarly, the sub-processor provisions under the SCCs, which include the options for a specific authorization or a general authorization to be able to use sub-processors, refer to obtaining authorization from the controller, again having this assumption that the sub-processor can actually be able to request this from the controller. In practice, we imagine that this controller point could be ignored, maybe ignored by organizations, and expect that perhaps a sub-processor will receive authorization or instructions from the exporting processor and rely on this, and rely on the exporting processor to notify the controller. Similar to the question that just got raised about amending the SCCs, and Renzo suggested you can have contracts in place to complement the SCCs. This may be something that would want to be covered off in a DPA. So dealing with this point and ensuring there was something expressly covered in the contract to ensure that the exporting processor was carrying out the notification obligation to the controller on your behalf. And then finally, moving on to the last one, I hinted that I would come back to audit provisions earlier. So the Standard Contractual Clauses explicitly include a reference to on-premise audits, which may be alarming for some suppliers. This appears in the controls to processor and processor to processor modules. So this is actually caveated with reasonable notice. However, all the lawyers amongst us will know that reasonableness is very open to interpretation, and also there's no sort of controls around this. So, i.e., the audit can only happen during business hours, for example. So again, this may be an area parties want to use their options of complementing the SCCs in a separate agreement to agree some sort of parameters around the audits, without, of course, conflicting with the provisions of the Standard Contractual Clauses. And then also, just to point out, in the P2P provisions, so processor to processor, whilst the new SCCs do not explicitly allow a controller to conduct that on-premise audit of the process, the importing processor, the controller can instruct the exporter to carry out an audit. And whether the exporter has decided to audit or it is auditing on the instructions of the controller, any information from that audit can be shared with the controller. And now handing over to Kirsten, who's going to take us through the final part of the session.
Kirsten, if you don't mind, before we start, I'll take another question or two since we are running on time. First of all, I have a question about governing law that can be chosen here. And the question reads, when you've got the non-EEA data exporter, and it's sort of just worth recapping that, one of the challenges in the old SCCs was that it imagined that a data exporter was always in the EU, but that's not the reality, because we've got extraterritoriality in GDPR under 3.2, for example, and you could be subject to GDPR and the transfer restrictions, even if you're, say, typically in the US. Anyway, in that sort of scenario, when you've got a non-EU exporter, do you have to choose the law? Because the governing law can be chosen by the parties, it says in the SCCs. Do you have to choose a European law, or can you use a non-European law? And the answer is, in 3 of the modules, you have to choose a European law, modules 1 to 3, which allow for third-party beneficiary rights. And there's a big question mark there as to whether or not Irish law could actually be used. But in module 4, the reverse transfer, it doesn't have that stipulation. It can be by a foreign law. So if you've got a European processor to a US controller, you could choose one of the US states as being the governing law, for example. Kirsten, sorry to interject. Over to you.
No problem at all. Thank you, Renzo. Right. Moving on then to my first of my substantive slides. Okay. So before I talk about the SHRMs 2 parts of the new EU SCCs and practical implementation, just wanted to have a little recap of the timetable for implementation. So, and bearing in mind on this slide, I'm talking here only about the EU SCCs. I'm not talking about any potential new UK SCCs. So, as you heard earlier, the new SCCs were adopted earlier this month. It was on the 4th of June. The new SCCs don't actually come into effect until the 27th of June. So we've actually got like a little waiting period of a few weeks. So then we've got another period up to the 27th of September, which is a 3-month grace period from the 27th of June, after which you have to stop using the old SCCs for any new contracts. But before that, you can use the new SCCs for new contracts once they come into effect. And then a bit further down the line, this is in December 2022, it's 18 months on, you can't use the old SCCs for either new contracts or for the old contracts that you might have already had that you still had in place, and everything will have to have been swapped over to the new SCCs. Right, next slide. So who are these SCCs for? And just wanted to go back to this because there's a new possibility has been introduced that we didn't have before under the old SCCs. So it was always the case with the old SCCs that you would have an exporter of the data who's based in the EU and an importer of the data who's outside of the EU. And the new thing that has been introduced is that you can now actually have an exporter of the data who's not in the EU. And that's been introduced to plug a gap that we had where you might have had an exporter of the data who was transferring the data and wanted it to be compliant with EU data protection requirements, but couldn't. Well, now you've got exporters that actually could potentially be caught by the GDPR by virtue of Article 3.2, and so that they can actually comply with obligations that they might have under the GDPR in terms of data transfers, they're now expressly stated to be able to rely on these modules. Next slide.
Before we do that, Kirsten, we discussed in preparation of this a quirk, maybe not a quirk, but something in the implementing decision, which is Article 1 or Recital 7. Most people, 3 people have now raised it in the question. So although we decided it was too niche a point to include, can I briefly talk to that point,
Yeah, please do.
if you don't mind? The question, there is something in not the SCCs themselves, but in the formal piece of law to which the SCCs are annexed, called the implementing decision, which says in Article 1 that this doesn't apply. You can't use the SCCs for a transfer from the EU to an entity outside of the EU when that recipient entity is itself subject to GDPR. And typically, and perhaps only, that will be under Article 3.2. So if you're sending data to someone outside the EU that's themselves subject to GDPR, these clauses say these clauses don't apply. Then how do you transfer data to them? The implication of that provision is that the European Commission consider that when you send data out of the EU to a non-EU entity itself subject to GDPR, you don't need to do anything. Now, that's a stance that the UK ICO has taken over the last couple of years, not particularly well publicised generally, and certainly not adopted by the other EU regulators. Now, it seems as if the European Commission, who published this piece of law, these clauses, agree with that interpretation of GDPR. Because if that interpretation is wrong, then there is no solution to send data from the EU to a GDPR covered entity outside the EU. The Field Fisher view on this is that it's risky not to do anything, but it's a defensible position. If you're really confident that you're about the position, then you could ignore SCCs and do nothing when you're sending data to an entity itself subject to GDPR. But it's risky. The regulators may disagree. The European Commission, although it's a formal decision, could only do something consistent with GDPR. And the European Commission's view as to what GDPR says might be wrong. So there's a little bit of risk there. It's a bit under the radar. And forgive me, those of you that aren't aware of this particular debate, so there's been a few comments and questions about it. It's a bit niche, but there's a question mark there. Kirsten.
Thanks, Renzo. So it now might beg the question, what's going to happen if you've got a transfer that's protected both under the UK GDPR and our UK Data Protection Act 2018, and also the EU GDPR. So which standard contractual clauses do you use? Well, a few points to make here, which are that the new EU SCCs are not actually recognised in the UK. And it's actually the old EU SCCs that are recognised in the UK because they became part of our law as retained EU law. So they actually remain valid in the UK, even though in the EU, they might be superseding the old SCCs with a new set. And these old SCCs are going to remain valid in the UK until such time as they're superseded by our new UK SCCs. So unfortunately, what that then means is that you might be in a position where you've got transfers of data which are protected, because it might be an agreement where you've got transfers from the UK and from EU. And in actual fact, what you're then going to need potentially is to use different sets of the standard contractual clauses. And I say potentially because there's there's these grace periods as well. And so I'll talk you through that now if we move on to the next slide. So let's say now we're at this point in time, or the 27th of June, when the new SCCs come into force. For an EU transfer, you could potentially still be using the old EU SCCs, whether it's a new or an existing contract, or you could be swapping to the new EU SCCs. But for transfers from the UK, you're going to have to stick with the old EU SCCs. Now fast forward through the 3-month grace period. So after that grace period expires, once you start putting in place new contracts for transfers from the EU, you're going to have to swap to the new EU SCCs. But for existing contracts, you could still be relying on the old SCCs, or you can use the new SCCs. But again, for UK transfers, you're still stuck with the old EU SCCs. Now, let's assume that between that 3 months and 18-month grace period that we have from the EU, the new UK SCCs come in force. We don't know at the moment whether there's going to be a grace period for those, or even, if we're being really optimistic, whether the ICO is going to let us just to continue to rely on the old EU SCCs for existing contracts. But assume that doesn't happen, the new UK SCCs are in force in the interim period. What happens then? Well, for EU transfers, for new contracts, you're going to have to use the new EU SCCs. For existing contracts, you can use the old SCCs or new SCCs. And then for the UK transfers, you're going to have to swap to the new UK SCCs. And then fast forward again, the 18-month grace period has expired that we've got from the EU. For all contracts, you're going to have to have moved to the new EU SCCs, and for your UK transfers, you'll be using the UK SCCs. So unfortunately, over the next 18 months or so, it's going to be a little bit complex in terms of sorting out your contracts. So next slide. And before I move on to
Kirsten, just there's a few comments on use of dual SCCs going forward. Those of you and the Phil Fisher teams have been discussing it, that when you've got to use both of them in relation to a particular transfer, EU ones and whatever's valid in the UK, and as Kirsten says, it could be the old the old EU SCCs, or it could be the new UK SCCs. If you've got to use both of them because of a particular transfer, then there is a view that on a risk-based approach, is the ICO really going to care, even though the UK doesn't formally recognise the EU SCCs, and this government certainly won't do anything to do that. One can all assume. On a risk-based approach, would the ICO really care if the data is protected subject to EU SCCs and not UK ones? It's a view that could be taken, and we're going to, I'm sure, explore that with some of our clients. Sorry,
yeah, and just to add to that, I mean, it is as Renzo said, this is a point that we've been debating in the team. Is a bit of a risk-based approach, but also to throw into the mix that there are the advantages to the new EU SCCs over the old ones, in that it's got the new provisions around SHRMs 2 in there, which I'll be coming on to in a minute. But before I do that, and before I look at some practicalities around implementing the contracts, just a word on flow down obligations. And I'm not going to go into lots of detail on this particular slide, and there's lots of information for you there to take away. But just a point to note that the modules 1 to 3 are very prescriptive around how you do flow down of obligations from the modules. So that flow down being, so you've got the exporter, the importer, and then the importer onward transfers that data to the transferee. And then how you deal with that is prescribed in the module. And there's two ways of dealing with that. And one is that the transferee either signs up directly to the model clauses, or the importer just flows down the provisions of the model clauses. And if it's a processor to controller one, module 4, then there's nothing being imposed. That was my quick word on that slide. Now moving on to SHRMs 2 and how the new SCCs are dealing with this. Well, they've built into the SCCs specific measures to address SHRMs 2, and these are contractual measures. There is, however, a big but. This does not get you out of doing transfer impact assessments, which post SHRMs 2 now need to happen. And you may also need to put in place other supplementary measures. And I say may because that could depend on your risk assessment and as to whether additional measures are needed. And I'll come on to that. So looking a little more closely at what these SHRMs 2 measures are in the SCCs, both the exporter and the importer must commit that they have no reason to believe that the laws and practices in the third country will prevent the importer from fulfilling their SCC obligations, having taken into account the following 3 elements: so the circumstances of the transfer, the laws and practices in the third country, and relevant contractual, technical, and organisational safeguards. So you'll see from the bullet points around the circumstances of transfer and laws and practices in third countries that the SCCs do in actuality introduce an element of a risk-based assessment here, a risk-based approach, which is different to what the European Data Protection Board draft guidance says, and it's hoped that the final version of the guidance will align with the SCCs. So in terms of that risk-based approach, as I said, you can look at the circumstances of the transfer and also the laws and practices in the third country. And in terms of elements to look at there, the SCCs say that you can look at things like practical experience and prior requests or the absence of requests. So it's the question of, you know, is anyone really going to be interested in looking at our data? So next slide, please, Renzo. Now, circumstances of the transfer that you can look at are actually prescribed within the SCCs, and this is the list of things that you can look at when assessing the circumstances of the transfer and doing your risk-based assessment. So the length of the processing chain, so how many are there in that chain, the numbers of actors involved, what are the transmission channels used, what are the intended onward transfers, which is sort of linked to the chain one, the type of recipient, the purposes of the processing, categories and the format of the personal data. So, you know, actually what data are we talking about here? The economic sector and also the storage location of the data. Next slide, please. Now, carrying on with the list of the importer commitments. So there's some commitments that they need to make around the transfer circumstances and also changes to their circumstances. So the importer has to commit to the exporter that they've made their best effort to provide all relevant information to the exporter relating to the circumstances of the transfer. So it's putting the onus there on the importer. And the importer also has to know.
Sorry to interrupt, Kirsten. I'm just conscious of time and my fault for putting so many questions. But we've got 10 minutes left and we need to speed up and get to the practical steps to do next.
Okay, yep, I'll whiz through. So final bullet point then, they also have to notify the exporter if there's a change of law or they're brought within the scope of the change of law, and it impacts their commitments. Next slide, please. And Other commitments around challenges and notifications. So these could potentially be quite onerous for the importer, but effectively they have to notify of requests for access, or if they become aware of any access by public bodies. And if actually they're not allowed to notify around that these requests have been made, they've got to make best efforts to obtain a waiver. And they've also got to give regular updates about the sorts of requests that they're receiving. Next slide.
And before we do that, one question for you, which was the very first one that came in actually about 4:10. How long do we give this before SHRMs rips these SCCs apart?
He's probably tweeting about it already, I think.
He did tweet about it already, didn't he? And the serious answer is, well, look, the case in relation to the old SCCs, of course, started back in 2014, didn't it? And then took 7 years.
Yeah.
There you go.
Thank you. So, so more on the importer commitments, and there's specific elements in the contracts now around the legality and minimization of requests. So if there is a request that comes in, the importer is now committed to reviewing whether it's legal, challenge it if they can, and if they're not successful in a challenge, they need to pursue an appeal as well. Seek interim measures to suspend any request, so just to put a hold on it. And actually only disclose the information when they really have to, and disclose the minimum required. Next slide. Now to the rolling out in practice. So just back to Brexit again, very briefly. So before the end of June, you'll want to be looking at what your transfers are from the EU to the UK, and putting in place your EU Standard Contractual Clauses, whichever version you want to use, for transfers to the UK. And we're assuming here that
we don't get adequacy.
Granted adequacy. Renzo's quite optimistic that we will. I'm a little more pessimistic. Next slide, please, Renzo. Before the 27th of September, so that's the end of the 3-month grace period, map your data flows from the EU and from the UK. Check your existing contracts. Do they actually automatically update to the new EU SCCs? And if they did, are you ready to comply with the new SCCs as they are? Also bear in mind that this is not just for your external third-party contracts. It will also apply to your intra-group arrangements for transferring data under the SCCs. You'll want to look at prioritising your contract updates. So I know many of you on this webinar may well be working for organisations where you've got hundreds, maybe even thousands of contracts to look at. So prioritising them will be hugely helpful. Assess your new EU SCCs. So, what do they actually contain? We've given you an overview on this webinar, but there's quite a lot in them. And you may find that there are measures that need to be taken internally to implement new processes or policies or technical measures. Also document your transfer impact assessments and identify whether you need to put in place supplemental measures over and above the SCCs as they're now drafted in the new version. And 6 and 7 there on the slide, I will add that these are items that have been they've been there since July last year when we had the SHRMs 2 decision. So if you haven't done that yet, these are overdue items. So next slide, please. Then before the 27th of December, you'll need to be looking at moving all of your existing contracts, if they're relying on the old form of SCCs, onto the new form of SCCs, and that's assuming that they haven't automatically updated already. And just as a footnote, you might not want to leave it until the full 18-month period has run, because actually the the contractual measures, particularly the SHRMs 2 contractual measures in the SCCs, are helpful to help you comply with the SHRMs 2 obligations, which, as I said, are overdue obligations. So there you might want to, at least for your priority contracts, move across as soon as you can. And then from a UK perspective, well, we don't know exactly the timeframes from this, but eventually there will be an exercise as well of moving your contracts from old EU SCCs onto your new UK SCCs. And next slide, please, Renzo. And then finally, in terms of that prioritisation, how we expect this will pan out, and these are conversations that we're having with our clients as well. If it's low risk, the data transfer, what we may well see is unilateral letters being sent out, similar to the way that the processor clause letters were sent out when the GDPR was introduced, where you send or you receive a letter that says, by the way, we're swapping to the new provisions, and you don't need to sign, it's just going to apply automatically. Whether that's a valid legal way to update your contract is another matter, but it's a quick fix way of doing it. Then you may well get your medium risk contracts and data transfers where there's more effort. So you might have prepared a template contract, incorporating your standard contractual clauses plus your extra SHRMs 2 measures. And then you've got your higher risk contracts where we're anticipating there will be much more bespoking of the contracts and negotiation, and then incorporating your SCCs, SHRMs 2 measures, and also more effort around describing all of your data flows. And where it's a low or medium risk sort of data transfer, if you are squeezed for resources internally, that's where you might want to consider using external resources for your repapering exercise, such as Field Fisher's Condor. That's it from me. Thank you very much, Renzo.
Thank you, Kirsten. That's great. Thank you, everyone, for joining. I mean, I'm not sure. I'm slightly overwhelmed with the number of questions we've got here. So overwhelmed with the number of questions we've got here. We're going to try to answer them in writing, given the volume. It might take us a couple of weeks to get round to all these. So if you've got anything particularly pressing, please do contact your usual Field Fisher contact. So the message for today then is, no need to panic. We've got some new SCCs. We knew that were coming. There is an initial transition period which expires in September this year, where you can begin to think about how to operationalize for the new world using the new SCCs. When you begin to have to use those, data mapping, dealing with subject rights, everything that you ought to have done for GDPR, hopefully will help that, and it shouldn't be too much of a heavy lift. But the earlier you start and get to grips with it, then the better. And then there's a longer transition period where, as Kirsten just highlighted now, you begin to think about transition in a way your existing contracts to the new world. And we have this big uncertainty about the UK. Actually, a couple of questions on that. No, I don't think that the UK will recognise formally the EU SCCs. We have a question about whether any UK SCCs are going to be similar to the EU ones. Well, I think the answer is yes. I mean, they're bound to be similar, I suppose, because they both reflect GDPR Chapter 5 requirements, and in that sense, that substantively, there will be great similarity, but they're not going to be identical, especially in things I think such as how to deal with SHRMs. So you're still going to be left with either adopting both in relation to pan-European UK and EU transfers, or taking a risk-based view. On which note, Thank you all for joining. I do hope it was helpful. I think from the comments, some of you do have some more questions, but I hope this helps in planning for your weeks and months ahead. We will, again, a few questions about this, we will send slides around. There will be a recording, actually it will be on YouTube. You can share with your wider teams. We do try and deliver a webinar every month or so. Today's was obviously organised in a hurry, so actually the next webinar is next week on Thursday. So join Leonie, Kate and Rob on handling personal data breaches. So if you haven't signed up for that one yet, that should be a great webinar. Thank you very much, everyone. Goodbye.